Good morning and welcome to the Computer Channel. Today's Dossier programme looks at negotiating IT contracts. It's a packed programme we've extended by 15 minutes. The programme will now finish at 11:15, so please make sure if you're recording the programme you adjust the timing on your video machine. Well, anyone who's been the victim of an errant supplier, maintenance company or finance house knows that contractually speaking, these companies really do get away with murder. Many contracts seek to exclude culpability if your computer never even arrives, and in most cases your solicitor or finance people don't have the technical know-how to write in the kinds of clauses that guarantee the computer will work, much less do what you need it for. Basically, you need help. My guests in the studio this morning have become experts providing the sort of help that you need. Simon Charlton is a partner with Dibb, Lupton, Broomhead and Pryor. Simon will cover the general issues you should consider when you enter into any contract. Chris Reed is a lecturer in IT law at Queen Mary and Westfield College, London University. Chris will tackle hardware purchasing contracts and pick out the dangerous clauses you must watch out for. Ranald Robertson is a partner with Stevenson Harwood. Ranald is a former legal advisor to the SEMA Group and this morning covers software licensing. My final guest is Simon Elsom. Simon is an associate in the Intellectual Property and Technology Law Department at Baker & McKenzie. Simon will cast an experienced eye over maintenance and support contracts. But let's kick off today's packed programme with my first guest, Simon Charlton. Simon is a partner with Dibb, Lupton, Broomhead and Pryor. He's a member of the British Computer Society's Intellectual Property Committee and the UK's representative for CLIM, a committee of practising lawyers and academics who are concerned with the development of IT law in Europe. Simon.
How to get the best out of your supplier implies a process of extraction. At best, a negotiating ploy, and at worst, an adversarial conflict. Procuring a computer system should be a cooperative process to which both supplier and user contribute. If the project goes wrong, the law will decide who bears the costs of failure. The contract between supplier and user can heavily influence this issue, so we must look carefully at the contract, recognise the exposure that it creates for each party, and if that exposure is too great for the party we represent, we must negotiate changes. Let's look at the 6 abilities of computer system procurement. These are suitability, compatibility, acceptability, maintainability, expandability and transportability. The first, suitability, is also the most important. A system which is not suitable for a user's particular needs may never work for him. Unless a supplier is really expert in the needs of the business sector in which the user operates, it must be the user's responsibility to define his own particular needs and to communicate them precisely to the supplier. This is usually done in the form of a user requirements specification, to which the supplier can respond with a proposal, setting out just how the supplier intends to meet the user's expressed needs. Very many system failures stem from the user's inability to recognize and explain his needs with sufficient precision. Not surprisingly, the system provided for him may precisely match his supplier's proposal but still be unsuitable for the user. Disputes then follow, each party blaming the other. The second ability, compatibility, refers to the ability of a system's various components to run together as a complete system. So, the equipment, the operating system, and the application software must all be compatible with one another. Relatively minor incompatibility between any of these components can create major operating difficulties. A common solution to this problem is to appoint one supplier as the main contractor, with responsibility for procuring, delivering, integrating, and implementing the complete system. This unitary supply principle puts additional responsibility and risk onto the main contractor, for which he will usually charge an additional fee. That extra fee may prove a sound investment for the user, if only in saving the management time which he might otherwise have to spend on tracking down the defaulter when a complete, complex system procured from a number of separate suppliers fails to perform. Acceptability is the third ability we must look for, and is to be tested against clear contractual obligations agreed and set out before a firm order for the system is placed. There may also be agreed benchmarks to be satisfied, and the user will himself want to reserve the right to prepare test data demonstrating that the system as installed in fact performs as it should. Once the system has been accepted, the user's concern shifts to maintainability. The system may have teething faults, usually covered by a warranty period. But even after this period has expired, other faults may surface and will need correcting. More importantly, changes in the underlying operating system and in the user's own requirements are likely to lead to calls for enhancements and modifications to the application software. Without the ability to make these changes, the system may quickly become unworkable and even dangerous to use. Expandability comes fifth, and is typically needed to handle unforeseen increases in the user's processing volumes. And finally, transferability is necessary when the user outgrows the equipment on which the system was originally mounted and wants to move to a larger machine. We've already looked at the importance of suitability and the need for a user requirements specification. The contract between the supplier and the user should incorporate a reference to the user requirements specification and should require the system, as delivered, to match it. Acceptance tests should be carried out by the user, usually with the supplier's help, and usually using test data prepared by the user. The preparation of effective and comprehensive test data is difficult. The data must test and demonstrate the ability of the system to perform the functionality and handle the volumes required by the contract, as set out in the user's requirement specification and the proposal, while at the same time delivering adequate response times under peak load conditions. Sometimes a relatively brief period of testing will prove these points, but in other cases it may be necessary to run a system under normal operating conditions for a number of days or even weeks or months to prove that it meets defined acceptance criteria. It's in the interests of both supplier and user that acceptance tests be promptly and effectively carried out. The supplier wants to know that the system is acceptable, and so that he can treat the implementation process as substantially complete, and so that he can be paid. The user does not want to accept a system which is not right, thereby incurring an obligation to pay for it. And if acceptance tests are not properly carried out, the fact of acceptance may be disputed, and the user may raise post-acceptance claims alleging breach of contract by the supplier. Acceptance is a critical point. Acceptance means that the supplier has properly performed the contract to develop and deliver the software, and that he is entitled to be paid. The obligation to pay then becomes a money debt due from the user to the supplier. If the user subsequently finds that there are defects in the software, he will have lost his right to reject the system, and although he may in theory have a claim to damages against the supplier for breach of contract, his claim may not be enforceable. This is because it's common practice in the information technology industry for suppliers to use contracts which exclude the right for users to claim damages. What if the system as installed fails to pass its acceptance tests, and despite opportunities given, the supplier fails to achieve acceptance test standards of performance? The contract should then set out the user's right to reject and the consequences of rejection. These consequences will usually be, first, return of the software and the other components of the system to the supplier. Secondly, repayment to the user of any amounts already paid to the supplier for the system. Sometimes this repayment will carry an interest charge, and sometimes it will be extended to include other amounts paid to the supplier, for example, for consultancy and specification services. Cancellation of the rest of the contract should follow, and exclusion of any other liability of the supplier for failure to perform, so that the user cannot, for example, claim damages for loss of his bargain. To be effective protection for a user, termination of the contract on rejection must also include a right to return any equipment supplied to the user as part of the contract. The ability to maintain software after acceptance is critically important. Maintenance may come from the original supplier of the software or from a third party, or it may be undertaken by the user himself. If the software is a standard mass-marketed product, continuing support will not usually be a problem. But if the software has been specially developed or modified to meet a user's particular requirements, support of the non-standard modification is not likely to be standardly available. The safest course is to take source code with the software product so that you can either have your own technical staff look after the code or can engage a third-party maintenance provider to do so. Most software suppliers will be reluctant to part with source code, and more usually will urge their users to rely upon the supplier's own software support service. Before deciding to do so, a user should bear in mind that a contract to maintain software is not directly enforceable through the courts, and that damages for non-performance of the contract are unlikely to be excluded under the contract terms. An annual maintenance contract may not be renewed, or may only be offered for renewal at sharply increased rates. And without access to up-to-date source code, a user who has lost his original supplier's source of support may not be able to find an alternative maintainer. One possibility is to arrange for an escrow deposit of source code with either the National Computing Centre or the Computing Services Association, or some independent third party as an escrow deposit agent. The terms of the escrow deposit can provide that the deposited code and its associated documentation are kept by the agent and only released to the user in certain circumstances, for example, on the supplier's insolvency, or if the supplier fails to provide adequate support. The ability to transfer software to another machine or to another software supplier for continuing support may be vital to a user who has become dependent on the software. There are several factors which may prevent such a transfer. First, incompatibility. The software may run only on one type of machine or with an operating system capable of running only on one type of machine. The current move to open and interoperable systems may solve the problem in the years ahead, but may come too late to help our particular user. Secondly, copyright constraints may mean that the user's license includes no permission to transfer the software to another machine, and transfer may necessarily involve infringing copyright by loading the software into the second machine. Or express contractual provisions, either under the procurement contract or under the user's license, may prohibit such a transfer. If you plan to port your software to other equipments or to download your software across networks, you will need to be sure that you have the necessary permissions to do so. In conclusion, the key points to remember are: suitability. If you don't know precisely what you want, You won't be able to tell your supplier that what he is expected to provide. And you should not be surprised if you get an unsuitable system. Don't then blame your supplier. If you don't want to get stuck with a system that doesn't work, or won't perform as you told your supplier you wanted it to, make sure that your contract provides for acceptance testing and a right of rejection if the tests are not passed. And remember that a computer system is an organic, living thing which grows and changes and needs looking after. Be sure you have a secure source of software maintenance. And if you want to be free to move your programs to another machine or machines, make sure you have the right to do so and access to the source code so that you can exercise your rights effectively.
Thanks, Simon. Just to summarise Simon's talk, the 6 abilities of procurement are suitability, compatibility, acceptability, maintainability, expandability and transportability. Suitability is obviously the most important. Define your own needs and communicate them precisely to the supplier. Compatibility, make sure one supplier sees the whole system works properly. Acceptability, make sure the system works as it should before you buy it. Maintainability, cover future upgrades, teething faults, etc. Expandability, to handle greater volumes of work in the future. Transportability, for when you outgrow your kit and want to move to a larger system. Chris Reed, if I can kick off with you, really. I mean, do users on the whole say what they want?
Generally not, I think. Part of the problem is that although users know what they want in terms of their own business, they don't know what they want in technical terms. The supplier, of course, knows all about the technical language and can describe his system in those terms, but the user doesn't understand that. And so the two of them really have a language problem, which is very difficult to overcome.
Simon, how do you get around that?
I think I'd slightly disagree with Chris in that users very often don't even know what they need for their own businesses. What they tend to say is, I want a system which is suitable for a widget manufacturer. They've been widget manufacturers all their lives. What they don't appreciate is that the supplier's never made a widget in his life and really doesn't know what that involves. The consequence is that there is a complete failure of minds to meet, and a general purpose system is provided for a particular purpose and is unsuitable for that particular purpose. That's quite apart from the technicalities.
Yes, I'd agree with Simon. Too often I think the user looks to the supplier as an expert in their own business, whereas the supplier is an expert in the supply of computer systems. And it's a matter of bringing the two minds together and making sure that there is a common understanding of what the precise requirement is.
So what brings those two minds together, if you like?
Well, I think the starting point is to bring it together through the functional specification and enlist where necessary, if you don't have an in-house capability, to make sure that the user understands what he needs, to bring in help from by way of technical management consultants and the like to help him get a better understanding of the requirement, and working together with the supplier firm up on a functional specification which will be the baseline for the contract.
Yes, I'd actually say it's often when the lawyers get involved that people really start to think about their requirements, because the lawyer is starting to ask difficult questions.
Yes.
And I've actually been asked to look at contracts which are 4 or 5 years old to tell people what they agreed to 4 or 5 years ago, so they can actually decide what they're going to do now.
Yes, I think a further point to make on that is simply the point that you must also look to see what the user wants in future, not necessarily what he wants today. And it raises Simon's point that he made earlier on the question of expandability. What may be right today may not necessarily be right tomorrow, and I think a major problem is simply that users don't think ahead. No matter how good the system is, you cannot develop a system to meet requirements that you don't know about.
All right, well, let's just hold it there for a second and move on to Chris's next presentation. My second guest is Chris Reed, lecturer in IT law at London University. Chris is a regular speaker and writer on computer law and is currently writing a book on electronic banking law. Today he looks at tricky clauses to watch out for in your hardware contract. Chris.
About 10 years ago, a firm of solicitors bought an Olivetti computer system to run their accounts. They discussed their needs with the sales representative, but did not negotiate a proper contract. Instead, they signed Olivetti's standard terms, which dealt only with the system's technical performance. The system proved totally unsuitable for the firm's purposes. It was slow, difficult to use, and could not expand to cope with new business. None of these matters was dealt with in the contract. Luckily for the solicitors, they were able to persuade a judge that Olivetti were bound by the salesman's claims that the system would be suitable for their needs. But they had to take the matter to court, which cost both time and money, and then of course had to find another system which would do what they wanted. This case clearly illustrates the dangers of a poor contract. It also shows how unsuitable standard forms can be. They're very tempting. You get the lawyers out of the way in advance, you only have to pay them once, and you can save more money by copying a standard contract from somebody else. In the end, however, the lawyers profit by earning large fees from sorting out the consequences. The golden rule is simple. Standard forms are only for standard transactions. No matter how comprehensive your standard contract, it always fails to cover some essential point. So, negotiating is essential. Initially, you are likely to begin with the supplier's standard terms. These are always negotiable to some degree. How far depends on the buyer's bargaining power. For small contracts, you may only be able to negotiate the price. In large contracts, most of the terms will be negotiable. The important thing is to ensure that no essential terms are missing from the contract. Unfortunately, there is only time to look at a few of these terms in detail. I'm going to examine the main points to consider when negotiating. Remember, you are trying to define 4 things in advance. What is to be done, by whom, when, and for what price. The first term is the hardware specification. Agreeing a proper specification is often neglected. Purchasers dream that they might deal with a single supplier who discovers their needs, supplies the system as a complete package, and sets it up so that it only has to be switched on. This doesn't happen. Even where the supplier agrees to a contract like this, the buyer always discovers further requirements after the system has been installed, and often between signing and installation. There are 4 reasons for negotiating a detailed specification. It defines what the supplier will provide. It helps define the quality standards which must be achieved. If changes have to be made, it helps decide who bears the cost. It forces both sides to think seriously about what is really wanted and what is achievable. In all cases, the specification should state what software is to be run and any other hardware with which the system will be used. If compatibility issues are not dealt with at this stage, they are likely to lead to a dispute which won't be solved by the other terms of the contract. A specification must be as detailed as possible, including a complete description of all machinery to be supplied. This should include full model numbers. A Hewlett-Packard 7575 plotter costs 6 times as much as a 7440. Clear choices should be made where there are options. There should also be a technical description of its performance, which might need further explanation. For example, if the power of the CPU is expressed in MIPS or megaflops, the basis of calculation has to be known to make these figures meaningful. Many of these technical terms have been defined by standards organizations, such as the BSI and ANSI, which can be referred to in the contract. Once the specification has been agreed, the next term to consider is the warranty of quality. At the minimum, this should be a warranty that the hardware will perform substantially in accordance with its specification. The purchaser may want a further warranty that the hardware will suit his purpose, but the supplier will normally resist this. Of course, if the specification has been properly devised, the buyer will be as certain as he can be that the system will meet his needs. If there is no express warranty, quality can only be defined by Section 14 of the Sale of Goods Act. This provides that the hardware must be of merchantable quality and reasonably fit for any purpose the buyer has made known. Neither of these can be tested objectively, which increases the likelihood of disputes. It is probably in both sides' interest to exclude the terms in Section 14, and to define expressly the quality the buyer is entitled to expect. This leads us to exclusion clauses. The most common exclusions refer to a breach of description or quality, normally by adding to the express warranty an exclusion of all other conditions and warranties. It is also common to exclude liability for all consequential losses. These clauses need to be carefully drafted if they are to be effective. In order for an exclusion clause to work, it must be contractually binding, for example, in a written and signed contract. The clause must also be drafted so as to cover the breach that has occurred. There is a general principle that the more serious the breach of contract, the more clearly worded the clause must be if it is to exclude liability for that breach. Additionally, the courts have powers to examine exclusion clauses under the Unfair Contract Terms Act. In many cases, the courts have the power to strike the clause down unless it passes the test of reasonableness in Section 11 of the Act. To decide this, the court will take account of a number of matters, including the strength of bargaining position of the parties, whether the buyer received some benefit, such as a lower price, for agreeing to the clause, and whether the hardware was specially adapted to the customer's order. The courts have also held that the availability of insurance is a relevant consideration. The underlying question is primarily whether the clause is a fair allocation of risk between the parties. The price is never forgotten, but in most hardware purchases, the specification, and thus the price, is likely to change at some point. It is important to make clear in the contract which of these changes are at the seller's expense and which the buyer is to pay for. A procedure for making formal alterations to the specification and amending the price accordingly is most useful. In addition to agreeing the total price, it is important to agree when it is payable. This links in with delivery dates. A common practice in hardware contracts is to pay by instalments as the various parts of the system are delivered, retaining a proportion of the price until the complete system has been tested. The section of the contract which deals with acceptance testing is crucial. It should define a clear and objective procedure for deciding when the supplier has satisfactorily completed performance. Retaining a proportion of the price until this is done puts pressure on the supplier, and the fact that the procedure is objective helps to prevent disputes. It is also useful to include a liquidated damages clause, setting out a fixed compensation for lateness, perhaps at a daily or weekly rate, and a cut-off date at which the purchaser can treat the contract as terminated. If the amount of the compensation is in proportion to the likely losses from the delay, it will be enforced by the courts, even if no loss can in fact be proved. The question of intellectual property rights should also be considered in the contract. Patents, industrial designs and copyright can all exist in hardware, so a buyer may wish to consider an indemnity against his losses if a third party alleges that the hardware is an infringement. This is at least a point to consider in negotiations, though because it is so complex, specific advice must be taken. The existence of third-party rights presents a real danger at the leading edge of computer technology. In a recent case, the manufacturer of a graphics machine, the Quantel Paintbox, secured a ruling that its main UK competitor had infringed patent rights in the technology. Unless there is a successful appeal, buyers who have paid more than £100,000 for the rival machines could in theory be forced to stop using them. If I were asked to sum up, I would say there are three main advantages to a properly negotiated hardware contract. Identification of the issues, a clear statement of the obligations of both sides, and agreement in advance on how disagreements are to be resolved. The overall aim is a good working relationship leading to successful performance of the contract and an effective system. It may not be cheap to involve lawyers in your contracts, but it is even more expensive to ask them to sort things out when a contract goes wrong.
Thank you very much, Chris. In addition to Chris's summary points, avoid standard contracts. Negotiating is essential. Things to define in advance, of course. What's to be done, by whom, when, and for what price. Be as detailed as possible and include expected performance. And watch your exclusion clauses. Wording is crucial. Chris, is there such a thing as an airtight hardware contract?
I doubt it. I really do.
Obviously, the supplier is, in a way, is going to be trying to get away with as little as possible, and the customer is trying to get as much as possible into the contract. How do you decide when you've reached a sort of happy compromise?
Well, I think the thing is that you're not looking just at the contract as a thing in itself. It's not a one-off sale like buying a loaf of bread or even a motor car. It's very much a long-term relationship, much more so than a motor car, when you can at least take it to a different garage to have it serviced. So what you're really trying to do is to get into total agreement with your supplier to cover the potential disputes in advance, so that if, as is almost inevitable, something goes wrong with the system, bits of it don't work properly, time has to be spent to put them right, or even they can't be put right, that at least you can sort those out without actually breaking down the continuing relationship that you need to have an effective and working system.
Taking up Chris's point about the computer contracts not being a one-off situation, I think that raises the other vital point that Chris made about change control and the importance of having in your contract a mechanism which you can deal with the inevitable changes which will occur during the course of the procurement. Those changes could be due to a change in the user's requirement or his business or the wish to add new features. So that's another aspect of this fact that computer procurements are a dynamic transaction, not a one-off static one.
That's right. It's common to sign the contract and then forget it, and then 6 months later when the system is installed, it doesn't look anything like the system that's mentioned in the contract. And so if you do get a dispute, it's very difficult to try and sort it out.
How do you cope when those who originally signed the contract leave the company or do other things or whatever? You have new people taking over and there are changes that need to be made to the system. How do you go about coping, keeping the negotiation process that you originally started?
Well, I think unfortunately too often when the contract's signed off, it's put away in the bottom drawer and gathers dust over time. I firmly believe that the contract should be an essential tool of the project management of the procurement, and therefore whoever has responsibility for managing that procurement within the user's organisation should fully understand the terms of that contract and have it available to regularly refer to in the course of project meetings with the supplier and at other times.
Yes, I think just to underline that point further is that it is important to have regular meetings with your supplier.
Yes.
And it may well be that should be a term of the contract. Certainly in the contracts I produce, I put in precisely that stipulation that there are regular progress meetings. If for anything else, just to monitor progress in the development of the system, the hardware, the software, or what have you.
Clive, can I make the point that a hardware supply contract is very seldom a standalone transaction? It's extremely important to retain the right to reject the hardware if associated software doesn't work or doesn't work with it. So, if you're buying equipment from one source and software from another and trying to put them together, try to negotiate a deal under which you can send that equipment back if the software doesn't work, even though the hardware does. That's not easy, but it's a very important form of protection.
Yes, I think that's right. I didn't have time to make this point, but certainly in the specification should include the software that you want to run on it. And you want that at least mentioned in the specification, and I would think more than that.
Simon raised the point about compatibility and the fact that people will often look to a single supplier to supply what we call a turnkey system. Now, one of the problems I found in practice is that whilst you'll be looking to a single supplier, that supplier, in fact, will present the user with two or more contracts for the different elements of the system. And that means, from a contractual point of view, if something goes wrong with one part of the system, you don't necessarily have rights of rejection in relation to other parts which work satisfactorily. And that is, can cause real problems if you feel you have to reject the whole system because there is one essential element which is not working satisfactorily.
I suppose
That can quite easily be overcome with a short overriding contract to which, so to speak, you attach the components of the system, the contract for provision of the application software, contract for the supply of the equipment. And that brief overriding contract can actually give you a whole lot of protection in a relatively short document. The skill is to put it all together.
All right, gentlemen, we'll hold it there for the moment. We'll take a break now. In part 2, Randall Robertson on software licensing and Simon Elsom on maintenance. Join us, please, in a couple of minutes and prepare those phone calls. Welcome back. If you have any questions you'd like to address to my guests here in the studio today, the phone number to ring is 081 681 5280. 081 681 5280. My guests in the studio today, Chris Reed, Simon Charlton, Simon Elsom and Ranald Robertson, talking about IT contracts. Well, what kind of problems do companies run into with their contracts? We asked Barrister Alistair Kelman.
Main problems they run into are the computer system doesn't do the job the company thought it was meant to do, or the computer system wrecks the business, which is an extreme version of the first. The general problem is that when a company is putting in a computer system, it doesn't know what it is wanting. And the big problem arises because they are unable to specify it in the language that computer people understand. So you have a complete breakdown of communication, and what is supplied is not what the company wants, is what the manufacturer thinks the company wants. So the problem is worse these days in some respects, since companies get sold standard packages, slightly tailored for their operation. Sometimes they work perfectly if the operation is close to the reality, but other times there are particular quirks of businesses that mean that a system that looks as though it might work perfectly actually is completely unworkable.
Is the law changing in any particular way?
Well, the law isn't changing, but the practice of law is, in that a few years ago it was not possible to get summary judgment that's saying that there's no defence to the action when someone was supplied with a duff computer system, because the practice masters didn't really know about computers at all. Now it's quite standard practice that if you get sold a computer system for use in your business and the thing doesn't work properly, you can get summary judgment against the supplier. And that's a major change, because we're talking here of sums that can be as high as £100,000, £200,000.
Are there any interesting legal precedents or out-of-court settlements?
There have been a number of out-of-court settlements that have arisen. It is a tremendous shock for a computer company to have a writ landing on its desk claiming several hundreds of thousands or maybe millions of pounds for supply of duff computer systems. And of course they are going to try their hardest to stop that litigation getting to the courtroom. Most of the time they do, and there have been several settlements in the near millions.
And isn't there a real problem for the legal profession, with traditionally its background not involved in computers and computer law being so new?
There is a problem that those lawyers that are particularly familiar with computers are not as yet that familiar with the law, because they're not yet senior enough within the profession. It's a temporary phenomenon and it will change. Most lawyers that have recently qualified have had some experience of using computers in their university training, and there is a growing group of lawyers in all the major city firms, for example, that are very aware of computers and their use in business. And most large city firms of solicitors, not all large city firms of solicitors, can well advise on drafting of contracts, but make sure that they do not give an exemption clause signing away your rights for negligence against them.
Alistair Kelman with a barrister's view of negotiating IT contracts. Which takes me on to my next guest, Ranald Robertson, who is a partner with Stevenson Harwood and a former legal advisor to the SEMA Group. Today, though, Randall looks at software licensing.
Hello. Today I intend to discuss some key legal issues relating to software licenses. In doing so, we will be looking at some of the major needs and risks faced by software suppliers, why software is supplied under a license contract, the types of restrictions typically found in a software license, and then finally at some specific problem areas. Firstly, what are the key needs and risks of the supplier? In my experience, an understanding of these results in users being better equipped to negotiate the best possible deal. On the needs side, they include timely payment, effective protection of the valuable bundle of legal rights which exist in the software, a need to achieve a maximum return on investment, and, last but not least, maintenance of the supplier-user relationship. Now, in turn, several major risks faced by the supplier are, firstly, the problem of inadequate definitions of the user's requirements. Secondly, potential disputes over ownership rights. And, thirdly, the consequences of software never being 100% error-free. You may ask, why is software supplied under a license contract? In light of the commercial needs and risks which we've just examined, software suppliers have sought a legal device which enables each supplier to sell his products, but at the same time adequately protects the valuable proprietary rights in those products. What do we mean by a license? Well, the essential features of a license are, on the one hand, it is a permission to do something which would otherwise be unlawful, and, on the other, no ownership rights in the subject matter of the license are granted to the license user, or, in legal jargon, the licensee. Because of these two features, licensing has become the customary basis for supplying software packages. This is the case whether you are buying a complex banking or production control package, word processing software, or a spreadsheet. And there will be no difference if you're buying the software directly from the software developer, through a distributor, or even at a retail store or by mail order. So much for why software packages are supplied under a license contract. What then are the essential elements of a software license? First, there is no standard software license within the computer industry, at least not at this moment. However, a feature of software licenses is that the scope of use will be expressed in the form of a number of restrictions. Through these restrictions, the supplier sets out the user's freedom, or as we will discover in a moment, his lack of freedom, to use the software in particular ways. Typical examples of the type of restrictions to be found in a software license include these. Use will often be limited to a specific hardware installation at a particular location. There may even be restrictions on using the software in a network, which could have important operational implications. Copying of the disk or tape will be limited to the extent necessary for operational use and security, including the making up of backup copies. However, the copying of the user instructions and other manuals will usually require the supplier's prior permission. There may even be restrictions on modification of the software. There is also likely to be an express prohibition on decompilation or reverse engineering. Now, this is an issue which is currently the subject of considerable debate in relation to a proposed EC directive, which is designed to harmonize the legal protection of computer software throughout member states of the EC. It has been recently reported that the European Parliament supports the inclusion of a provision which will permit reverse engineering in certain circumstances, and this is notwithstanding any contract condition to the contrary. These circumstances are where it is indispensable for maintaining the program and for creating or operating interoperable programs. Proper identification of the licensed user is also very important, as another feature of software licenses is that they will be personal to the licensee. Now, this means that neither the license nor the software may be transferred to someone else without the supplier's prior consent. Indeed, the transfer of this program for use on other machines or by other parts of the user's organization may even be prohibited. A recent survey undertaken by Mori indicated that one of the principal areas of loss from software theft is the illegal copying of software within business organizations. This happens where one copy is bought legitimately, but a number of unauthorized copies are made and used on other computers within the user's department or organization. One finding of this Mori survey was that of senior managers who use a PC at work, 55% copy software illegally. Protection against unauthorized disclosure is also a fundamental aspect of any software license, and the user will be obliged to keep details of the program confidential. Whether the license is for a fixed or renewable term, or even perpetual, the supplier will have the right to terminate the license in certain circumstances. These will include where the user is in breach of his contract obligations or becomes insolvent at some time in the future. Whatever the reason for termination, the user will be obliged to stop using the software, which could, of course, have very adverse effects on the running of the user's business. Finally, let us look quickly at some specific problem areas which can result in pitfalls for the unwary. A major source of friction between software suppliers and users arises from inadequate definitions of the user's requirements and unrealistic expectations. Most problems come down to a genuine misunderstanding between what is desired and what is actually available. It is therefore vital that the software being supplied is adequately defined. The more detailed the specification, the fewer the problems. In addition, there should be an acceptance testing procedure to check that the software conforms, in terms of both functionality and performance, against its technical spec. This testing may range from a very simple test to some complex acceptance testing, depending on the complexity of the package. Another problem concerns ownership of the software. It will be often the case that the user will pay the supplier to develop some special modifications to tailor a package to satisfy that user's special requirements. Even where the user has commissioned and paid for these modifications, copyright ownership of those modifications will belong to the supplier as a developer, not the user, unless the contract expressly provides to the contrary. Understandably, many users may not be prepared to be put in this position of funding the development cost for modifications, which the developer is then free to sell to others. If this is the case, it is worthwhile exploring ways in which both parties can benefit from the commercial exploitation of these modifications. For example, it might be agreed that the developer owns the modifications, but a royalty is paid to the user on sales to others. Alternatively, reduced charges may be made for other development work, products or services. However, if the user feels that the modified software will give it a competitive edge, then restrictions might be imposed on the supplier's right to supply those modifications to named competitors of the user. Finally, a word of warning: do avoid joint ownership. One of the pitfalls is that the user has a potential exposure to liability from the supplier's marketing activities. There are, of course, other important issues, such as limitation of liability, which is one of the most contentious areas of software licenses. And Chris Reed's remarks on this issue in relation to hardware contracts equally apply to software licenses. The necessity for escrow arrangements to get access to the source code if the supplier fails to maintain the software or goes out of business will be another vital consideration for certain types of packages. In conclusion then, firstly, do remember that software licenses, like any other contract, are a matter of apportionment of risk and cost. Moreover, each supplier's standard software license purposely tries to minimize or eliminate the supplier's risk and liability. Secondly, carefully check that the various restrictions contained in the software license are compatible with your intended use, present as well as future. To the extent that any of these restrictions are unacceptable or unreasonable in light of your business needs, you must, of course, negotiate suitable changes before the license contract is signed.
Thanks, Ranald. In addition to those summary points, the main points again: two main features of a license: permission to do something which would otherwise be unlawful. No ownership rights are granted to the licensed user. There's no such thing as a standard license. You're faced with a number of restrictions, of course: the type of machine the software may run on, copying, use of services created by the software for a third party, and modifications, of course. Problem areas to look out for: an accurate definition of your needs, illicit copying, protection against unauthorised disclosure, and software ownership. Simon Elsom, if I can just start with you. The business of the whole area of escrow, to some people, may seem quite an unknown territory to try and get into. Just very briefly, what is escrow, and what first steps should you be taking to get to know more about it, basically?
Escrow is not an acronym. It's actually a real word. It's a legal word, if I may put it bluntly like that. What it basically requires, what it basically provides, is that the software developer puts in some third party's hands the source code of the software which he has, a version of which he has supplied to the user. The version which he would have supplied to the user would have been an object code form, which is not in a form in which the user can easily modify the software. And what it is basically, it's an insurance policy to provide that in the event that the supplier goes out of business or is unable to provide support, then the user is not left high and dry without maintenance, because he will be able, by virtue of getting the source code from the third party, from the escrow agent, to make his own arrangements for support of that software that he has in his possession. Of course, one of the problems with escrow agreements is to make sure that what is actually deposited at the escrow agent is the source code of which his object code is a version. And it is clearly essential, therefore, that as software, as we've said earlier, is a dynamic being, if you like, it is regularly upgraded and modified, that the modified version of the source code is also put into escrow for that purpose. Otherwise you might find the escrow, the copy in escrow is not compatible with the copy that the user has got.
Yes, and as Simon mentioned before the break, there are now within the UK at least 2 organisations who provide an escrow service which is specifically designed for computer software. And those organisations are the National Computing Centre up in Birmingham and the Computing Services Association here in London. And I always recommend the use of a specialist service like that, where you're looking at depositing the source material in escrow. Okay, that's what it is.
Actually,
Simon.
the National Computing Centre is in Manchester. It rains all the time,
yes.
and not Birmingham. I think it's the point about escrow is really a pointer to a much larger licensing point. All you ever get when you buy software in these circumstances is a right to use it in certain very limited ways. And that right will be cut down under the terms of the license contract. What you're buying is a solution. And that solution may be limited to the size of the particular machine for which the software is licensed. And if you want to move, for example, to a more powerful machine, which will give you better value, expect to have to pay more unless you've negotiated a general license to use that software on any machine in your possession. You get what you pay for, but what you pay for is written in the contract. You can't make any assumptions about it.
Just very briefly moving on to another. This area of software copyright is a complete minefield, really.
Indeed,
especially
yes.
with the recent happenings. How do you, if a particular software product contravenes copyright law, is that not the responsibility of the supplier to rectify that product rather than the buyer who bought it in all good faith and has?
Are you referring to
upon
the
it?
case where a supplier's product contravenes the
Yes.
copyright of another software product?
That's right, and the supplier the buyer unwittingly gets hold of it and
Yes, indeed. Well,
discovers it later on.
in that case, you would look to the supplier who has produced a product which is infringing someone else's product to make the necessary changes. And for that reason, the user would look to some undertaking on the part of the supplier that in that type of eventuality, the supplier at its own cost would make whatever changes are necessary to avoid his product infringing the copyright of some other product.
Reputable suppliers would normally provide that sort of undertaking, that sort of indemnity.
I think so. I'd say it's likely to be an increasing problem in theory, if not in practice, because what happens when somebody creates a piece of software specifically for a client, not for general release, is that they tend to take pieces of code they've written in the past, which probably have independent copyrights as separate works, as if you like, as separate programs, bolt them together with some new code, and that produces the new program. And all these little library routines, if you like, are the stock in trade. And so when the client says, I want to own copyright in the program, then, well, to start with, we don't know what they own copyright in, but if enough clients do that, all little pieces that are used to build that program start to be owned by previous clients.
Before we get too heavily into that,
Yeah.
I just make a very brief break there, just to really prompt you to phone in on 081 681 5280 if you have a question for our guests here in the studio. Finally, we come to my last guest, Simon Nelson. Simon is an associate with Baker and McKenzie and a founder director of the Federation Against Software Theft. Today, Simon looks at hardware and software maintenance. Simon.
I'm going to discuss some of the limitations and pitfalls contained in many hardware and software support contracts. I should, however, stress at the outset that my comments are general and are not directed towards the policies of any particular hardware or software manufacturer or maintainer. Further, legal advice should always be sought from a solicitor with expertise in this area prior to signing any hardware or software maintenance or support contract. Let me first make one or two general comments on such contracts. The user may be able to obtain many, if not all, of the support services elsewhere from so-called third-party maintainers. While this does not always apply, in many cases the user has a choice between the original supplier or manufacturer of the equipment or software or a third-party maintainer. However, the services third-party maintainers can provide in respect of computer software may be limited, since they are unlikely to have access to the software developer's source code, and access to the source code is essential in providing a comprehensive fault-finding service. Maintenance or support contracts for hardware or software invariably provide that on payment in advance of a fee, the maintainer will provide certain specified services for an initial period, typically 12 months. Many such contracts also provide that the agreement is automatically renewed for a further term of 12 months on the first anniversary of the date of the agreement, and so on. In each case, the user will be required to pay a renewal fee on or soon after the first anniversary, where the agreement has not been terminated. If for any reason the user wishes not to renew the contract, he may find he is liable to pay certain fees unless he is careful in complying fully with the relevant termination clause. For example, the user is often required to give prior written notice of his intention not to renew the maintenance contract. The required notice period can be quite long, typically 3 months. The giving of notice does not, however, relieve the user of his obligations to pay the fees due to the maintainer arising in the notice period. This may include an annual renewal fee payable in advance. Thus, if the user is not careful in his timing, the notice period could straddle the anniversary date, in which case the user may be required to pay a full year's fees in order to get out of the agreement. It is invariably the case that the maintainer would seek to exclude or at least severely restrict his potential exposure or liability to the user. For example, the contract is likely to provide that the maintainer is not liable for any loss or damage suffered by the end user as a result of the breakdown, save perhaps in the strictly limited circumstances where the loss is a direct result of the negligence of the maintainer, or where death or injury arises from the maintainer's negligence. Turning now to the types of services provided, these, of course, will depend primarily on the type of hardware or software concerned. Support services normally include 1. Preventative maintenance of hardware, including inspection, lubrication, adjustment and replacement of unserviceable parts. 2. remedial maintenance of hardware, including perhaps some consultancy and on-site visits during certain specified hours. 3. Remedial maintenance of software, including advice or consultancy by telephone, investigating problems arising with the operating the software, supplying a corrected version of the software, or instructing the user on methods of avoiding or minimizing the effects of the problem. And finally, supplying updated versions of the software and newsletters from time to time. All of these services may be subject to certain restrictions, or in certain circumstances are available only at extra cost. Let me give you some examples of what I mean. Many of the examples I will give are taken from hardware maintenance contracts where the maintainer is also the manufacturer. Where a computer system is required to operate 24 hours a day, 7 days a week, the user is likely at some time during the useful life of the computer system to require an on-site visit urgently or require technical advice outside office hours or at weekends. Many hardware support contracts provide that the principal or main period of support is during office hours. There may be provisions for support outside these hours, although this is likely to be subject to an extra charge. Further, such support may be subject to the important proviso that the maintainer is required only to exercise its reasonable endeavours, or that it is provided subject to the availability of staff, and therefore that the maintainer could not guarantee service outside these hours. The result could be good support within office hours and very little outside when it is needed. Hardware maintenance contracts often give an estimate of the response time, that is the time taken following a request for support to the on-site visit. Response times should not be confused with the downtime of the system, that is the period in which the user's computer system is not operational. The downtime may be far longer than the response time, particularly if the person who visits the computer installation is merely the engineer's apprentice and has neither the experience nor the spare parts and tools to rectify the reported error. Further, the contract is likely to provide that the user bears the maintainer's subsistence, accommodation and travel costs in accordance with the maintainer's then current rates. This underlines the importance of raising with the maintainer in the course of negotiations who of the maintainer's staff will be available to visit the computer installation in the event of a call-out. The contract should stipulate that the person who visits the user's site has the necessary expertise, tools and spare parts to rectify the reported problem then and there, and without having to make several trips back to base at the user's cost. Further, the response time is likely to be calculated by reference to the office hours of the maintainer. Thus, a response time of, say, 4 working hours could mean that when the call was received on late Friday afternoon, the maintainer could visit on Monday morning without being in breach of the agreement. In the meantime, of course, the user may not be able to use the computer over the weekend, with all the attendant disruption that may cause. In many cases, a user's computer system is likely to include equipment and software of several different manufacturers. It may be that the system breaks down because one component is not fully compatible with the others. The maintenance contract may therefore include a provision that unless the component parts are approved by the hardware manufacturer, any defect arising from use of the non-approved component falls outside the maintenance services, in which case the maintainer is not obliged to rectify the problem, or that remedial services are available, but only when staff are available and subject to an extra charge. If any such restriction is included in the hardware maintenance contract, the user should insist upon the manufacturer supplying a list of approved hardware and software products and ensure that his system contains those products and only those products. All computer equipment is to a greater or lesser extent sensitive to dust, humidity, extremes of temperature, static electricity or power failure. The maintenance contract is likely to provide that the remedial maintenance services do not cover breakdowns caused by certain environmental conditions arising. If, for example, the air conditioning equipment breaks down for any reason, with the computer equipment breaking down as a result, the user may face a substantial bill for the repair or replacement of the computer equipment, as well as for the air conditioning equipment, because their repair falls outside the scope of the agreement. This underlines the importance of taking out adequate insurance to cover this eventuality. Hardware, in common with software, regularly undergoes modifications as new versions are developed and released. There may be a requirement in the maintenance contract that support is provided only in respect of the latest version of the hardware, the previous version being supported for a limited period following the release of the latest version. The latest version would, of course, be offered to the user, although its supply and installation may be subject to an extra charge. Thus, the user may be forced to migrate to the new version at extra cost in order to continue getting the support he needs. Many of the points mentioned previously in the context of hardware maintenance contracts apply equally to software maintenance contracts. There is, however, one further point I should mention which applies specifically to software maintenance contracts. While there are many different types of software maintenance contract, all, without exception, stipulate that the services are provided only where the copy in the user's possession has not been amended or adapted in any way by the user, except in following instructions given by the developer. One of the reasons for this restriction in the context of providing a fault-finding service is that a method by which bugs are detected and rectified involves being able to reproduce them on the developer's system. This the developer would not be able to do unless he is sure that the copy in his possession is in all material respects identical to the copy in the user's possession. Thus, in many software support contracts, software developers specifically exclude from the remedial maintenance services defects which cannot be reproduced on the developer's system. Yet it may be exactly these intermittent, non-reproducible defects which cause the greatest problem, and in respect of which the user requires a troubleshooting remedial maintenance service. Many of the problems I have briefly mentioned can be avoided if the DP manager or user is aware of the pitfalls and takes the following steps. Firstly, depending on the type of computer system, the short list of companies able to provide the support he requires may not necessarily be confined to the hardware or software manufacturer. There may be several third-party maintainers offering adequate support. It is well worth shopping around. In certain cases, a single maintainer can support all the items of hardware and software of the user's system. The advantage of contracting with a single maintainer, rather than with two or more maintainers for the hardware and software, is that it avoids one maintainer being able to pass the buck and claim that rectifying the reported problem is someone else's responsibility. Secondly, always get professional legal advice prior to signing a maintenance contract. In particular, be aware of the circumstances in which the contract expires or can be terminated, the circumstances in which the user is liable to pay extra fees, the services provided, whether they are available outside office hours, and any other restrictions on their availability. Thirdly, the user must have a clear idea from the outset of the services he expects from the maintainer. He should be prepared to negotiate to get what he wants at a reasonable price. Fourth, no matter how comprehensive the support services are, they provide no more than a safety net in the event of problems arising with the computer system. These services should not, however, be considered in isolation from other methods of recovering from a system breakdown. Thus, the user should carefully consider, amongst other things, taking out appropriate insurance. Last, and not least, the user should, of course, take all such steps as is necessary to minimize the risk of a catastrophic breakdown or serious loss of data, including the making of backup copies of software, subject always to the relevant software license, use of a backup system, and the making of backup copies of data.
Thank you, Simon. If I can just come to you first, Ranald. The level of service you get from maintenance companies varies enormously. Are there any guidelines you can sort of put into place that will give you a uniform level of service so you know what you're getting at any one moment in time?
Well, I think you have to look at what are the levels of service you require for the particular system that's being installed. And so it's vital that you have a set of criteria which is setting out levels of performance and reliability, and you can test your system during the acceptance testing phase against those criteria.
Simon.
Yes, I think that's right. I think that the whole problem with maintenance is you don't know what you're getting until the circumstance arises, and it may well be that you're faced, hopefully, mercifully, very infrequently with some dreadful catastrophic breakdown.
I mean, how do you measure performance? It's a very subjective thing, presumably.
It is a very subjective thing, and I think, as Ranald says, the measure of performance must be with what the user requires rather than what the supplier is prepared to give.
Yes, I think one of the common problems is that suppliers will refer to response times in their contract, but it's unclear what they mean by a response time. Does a 4-hour response simply mean that if the supplier picks up the telephone and answers it, he's discharged that responsibility? So I think it's important in relation to that sort of commitment that you spell out what is meant by a response time. Does it mean that the supplier's engineer has to be on the site of the user within that period of time, or whatever?
Best endeavours is a much used phrase now. I think most buyers will already be wary of that phrase, but does it still get included in contracts?
Yes, there is a legal distinction between best endeavours and reasonable endeavours, and it's preferable from the user's point of view to get that obligation of best endeavours on the part of the supplier.
Yeah.
Simon.
Because you need support during the life of your system, it's very important to have a commitment, in my view, from the supplier, particularly of customised software or custom-written software, that he will provide support for a period of, say, 3 or 5 years. That's one side of the commitment. The other side is, what's he going to charge for that service? The worse the software, the more expensive the service will be to provide. The better the software, the less the expense. It's therefore reasonable to say to a maintenance supplier, please promise to provide this support at a proper level for, say, 5 years, and please promise that you won't increase your charges by more than, say, the greater of 10% per annum or the retail price increase during that period. That way you get a commitment from him that he'll keep what he supplied going at a proper level.
Yes, that's
Very, very briefly, Chris.
That's
We've got
actually
about 15 seconds.
I was just going to say it's a very important point, because if you don't spell out what renewal costs are, you're entirely at the maintainer's mercy. He can double or treble his charges, and you have to pay them.
Thank you very much. Well, again, that's all we have time for today. I'd like to thank my guests, Simon Charlton, Chris Reed, Randall Robertson and Simon Elsom, and of course you for watching. Next week's Dossier programme is the second of 2 programmes on security and can be seen next Wednesday morning at 9:30. If you haven't subscribed yet, please call Nick Bancroft on 071 730 2222. I'll just repeat that for you, 071 730 2222. I'll be back tomorrow morning at 9:30 with analysis. I hope you'll join me. Until then, it's goodbye from the Computer Channel. Goodbye.